committing a crime,
instead of doing
the work to rehabilitate themselves, they're focusing on how wronged they are.
Bill Cosby did not let that go.
So what I decided as a trial judge was that I was going to make sure that everyone who was in my room understood all of the procedures through.
Do I see them? I sit there. When I said it, so I did I sit there, my hands wanted to go. And then
as I said about
the people who say shit on
pornography cases, I focused on the harms of the behavior that was at issue. When I sentenced a defendant, I made clear in every case.
Just want to show that captions is unavailable.
This is what you've done.
That's right.
Here is the damage to our society.
The basis for the institution of marriage is the practice.
So I'm just chilling in my garage one day, and her name comes off my lips as a woman who opts to rape. Don't say it. We went crazy. She said, let's do it. I said, do you know who this is? So I'm going to try this again. I was chilling in my garage, and randomly, a woman by the name of the woman in this video with these dreads. That's it. Up in for raping someone simply for laying on their mother's couch. That's it. So, not once, but twice, someone keep yelling on my lips, yelping, don't say that. Not once, but if I sit there and listen, then I'm about to answer. Who is this? I sit there, I'm about to answer. If it is me, when I went crazy. So, in order to conduct a criminal investigation, one must go to the police. And that's it. When we answer, do you think we dumb? I sit there and listen. If I'm back, I answer. Then I sit there and listen. When we went crazy. So I sit there, then I sit there and listen. Then when I said it's on her mouth, then I said it's on her lips. Then I said that on her lips. When I went crazy. I said that on her lips. Then I said that on her mouth. Then if it is me, I said that. That's right, sit up. So I utilize the microphone because the blurting coming off my lips is, I too want to speak words about simply stating waste bill. If I'm about to answer, do you think we dumb? Just sit down. I'm about to mention if it's there in my when we went that sit on this. So I wanted to be able to record how often durations these women like playing with voodoo magic. If without creation, when we first that shit out using every single court case Ted Cruz placed on that damn bulletin board. If I said that, then I ain't said, and then it's been going on my recordings for so long that when I start to talk, I get interrupted with this if, and then they let me know I said that with her mouth. Don't say it. We answered when we went crazy, but I did get my words to hit the microphone. If back I answered when we went crazy. She said there, and they're about to act like I'm innocent. It's usually when I just told the truth about what the fuck is going on. If we back, we innocent. Do you think we dumb? She said there, I'm back, I'm innocent. I'm prepared, I'm back, I'm innocent. Well, we wink dirt. They share this.
I understood from my time as an appellate defender that a lot of defendants go through the system and don't really understand it. And the problem with that, from our society's standpoint, is that when people go through the criminal justice system and don't have a good understanding, they tend to not take responsibility for their own actions. They tend to be bitter and feel as though the justice system has wronged them, and so while they're doing their time, rather than reflecting on the
So I
fact.
don't know how many times I done heard, welcome to America. That's it. Who's your goddamn president? That's it. What the fuck you mean you are a U.S. Americans? That's it. So, that don't say it persona, a person. It's not me. My guess is Clarence Thomas. That's it. She said, fuck, we went crazy. She said, then I said, then I said,
that this is the consequence that they have to face for actually committing a crime. Instead of doing the work to rehabilitate themselves, they're focusing on how wronged they are, how victimized they feel. And so what I decided as a trial judge was that I was going to make sure that everyone who was in my courtroom, and especially the defendant, understood all of the procedures that we were going through, all of the steps. I spoke directly to them. I asked them, do you understand what's happening? Because I wanted them to know. And then even perhaps more importantly, as I said about my child pornography cases, I focused on the harms of the behavior that was at issue. When I sentenced a defendant, I made clear in every case, here is the problem. This is what you've done. Here is the damage to our society.
The basis for the institution of marriage is the practice for millennia and the recognition that marriage was between a man and a woman. Now, don't get me wrong. I'm not arguing the merits or lack of merits of same-sex marriage. I believe the states and the voters can choose what they will, and that's their prerogative, and I think that's legitimate. But when the court overrules the decisions made by the people, as they did in 32 of the 35 states that decided to recognize only traditional marriage between a man and a woman, that is an act of judicial policy making, is it not?
Senator, the Supreme Court has considered that to be an application of the substantive due process clause of the 14th Amendment.
Well, one of the things that concerns me is here is an example of the courts finding a new fundamental right that is mentioned nowhere in the document of the Constitution. That's the product of simply court-made law that we're all supposed to salute smartly and follow, because 9 people who are unelected, who have lifetime tenure, whose salary cannot be reduced while they serve in office, they decide, 5 of them decide that this is the way the world should be.
How do you think we can work to maintain the public's confidence in the court? What do you see your role in that?
Thank you, Senator. Public confidence in the court is crucial. As has been said here earlier, the court doesn't have anything else, that is the the key to our legitimacy in our democratic system. And I am honored to accept the president's nomination in part because I know it means so much to so many people. It means a lot to me. I am here standing on the shoulders of generations of Americans who never had anything close to this kind of opportunity. From my grandparents, who had just a grade school education, but instilled in my parents the importance of learning. And my parents, who I've mentioned here many times already, who were the first in their families to get to go to college. So this nomination, against that backdrop, is significant to a lot of people. And I hope that it will bring confidence, it will help inspire people to understand that our courts are like them, that our judges are like them, doing the work, being part of our government. I think it's very important.
Federal public defenders don't get to pick their clients. They have to represent whoever comes in, and it's a service. That's what you do as a federal public defender. You are standing up for the constitutional value of representation.
Is it your view that society is too hard on sex offenders? You say they truly are shunned in society. You wrote that many of these laws are products of a climate of fear, hatred, and revenge. So just is that still your view? I mean, do you think that these laws are too tough, that we're too tough on sex offenders? Explain what you meant.
Many years ago, as a law school student, I was evaluating a new set of legislation, state laws about registration, and I was analyzing them as law students do. It wasn't about the sex crime, it was about the characterization of the law. Is it a punitive law? Is it a prescriptive law? And how would a court go about determining that? That was the frame that I used then. It could have been about anything. It was about the characterization of legislation.
1728 of the Harvard Law Review. This is your conclusion. In the current climate of fear, hatred, and revenge associated with the release of convicted sex criminals, courts need to be especially attentive to legislative enactments. So that's a conclusory statement. You're saying that there is a climate of fear, hatred, and revenge that are informing these laws.
With all due respect, my article is now in the record. People can read it and they can see that I was evaluating these laws not to determine their constitutionality, not to say that they shouldn't be enacted, but to talk about the ways in which courts make determinations about the character of the law and all of the consequences that follow from them. I was doing what judges do, which is look at the statute, 18 USC 3553A, exercise discretion as Congress has required us to do, take into account all of the various aspects of a particular case and make a determination consistent with my authority, my judgment, and understanding fully the egregious nature of the crime.
Anti-Racist Baby by Ibram Kendi. And there are portions of this book that I find really quite remarkable. One portion of the book says babies are taught to be racist or anti-racist. There is no neutrality. Another portion of the book, they recommend the babies confess when being racist. Now, this is a book that is taught at Georgetown Day School to students in pre-K through second grade, so 4 through 7 years old. Do you agree with this book that is being taught with kids that babies are racist?
I do not believe that any child should be made to feel as though they are racist or though they are not valued or though they are less than, that they are victims, that they are oppressors. I don't believe in any of that. But what I will say is that when you asked me whether or not this was taught in schools, critical race theory, my understanding is that critical race theory as an academic theory is taught in law schools, and to the extent that you were asking the question, I understood you to be addressing public schools. Georgetown Day School, just like the religious school that Justice Barrett was on the board of, is a private school.
Okay, so you agree critical race theory is taught at Georgetown Day School?
I don't know because the board does not control the curriculum.
Are you comfortable with these ideas being taught to children as young as 4 and in respect to the first book, as young as 8 and 9 in respect to the second book?
Senator, I have not reviewed any of those books, any of those ideas. They don't come up in my work as a judge, which I'm respectfully here to address. Girls, you had to deal with me juggling motherhood and job responsibilities, and I didn't always get the balance right. And so I hope for them, seeing me, hopefully you all will confirm me, seeing me moved to the Supreme Court, that they can know that you don't have to be perfect in your career trajectory and you can still end up doing what you wanted to do, that you just have to understand that there are lots of responsibilities in the world and that you don't have to be a perfect mom, but if you do your best and you love your children, that things will turn out okay.
Well, I'm sure your mom probably feels she wasn't perfect, but things have turned out okay.
In your nomination, did you notice that people from the left were pretty much cheering you on?
A lot of people were cheering me on, Senator.
That's true. Did you know that a lot of people from the left were trying to destroy Michelle Childs? Did you notice that?
Senator, a lot of people were supporting various people for this nomination.
So you're saying you didn't know there was a concerted effort to disqualify Judge Childs from South Carolina because she was union busting, unreliable Republican in disguise?
Senator, I'm a sitting judge. I was focused on my cases.
The answer is no, I didn't know that.
No, I didn't know
So
that.
your judicial philosophy is to rule impartially.
No, my judicial philosophy is to rule impartially and to rule consistent with the limitations on my authority as a judge. And so my methodology actually helps me to do that in every case.
So you wouldn't say that you're an activist judge.
I would not say that.
But here's what I would say. That every group that wants to pack the court, that believes this court is a bunch of right-wing nuts that are going to destroy America, that consider the Constitution trash, all wanted you picked. And this is all I can say, is the fact that so many of these left-wing radical groups that would destroy the law as we know it, declared war on Michelle Childs and supported you, is problematic for me.
Roe v. Wade, let's talk a little bit about that. It's come up touch today. In my opinion, that was an awful act of judicial activism and has cost the lives of over 63 million unborn children. And nearly 50 years later, this shameful ruling remains binding precedent, but the battle is being fought in the courts. And as you know, and as we discussed when we visited, the Supreme Court is reconsidering whether the Constitution protects the right to an abortion in Dobbs. And if you're confirmed, you will be in a position to apply the court's decision in Dobbs, whatever that decision is going to be And you've talked about following precedent and what the court decides. So do you commit to respecting the court's decision if it rules that Roe was wrongly decided and that the issue of abortion should be sent back to the states?
Senator, whatever the Supreme Court decides in Dobbs will be the precedent of the Supreme Court. It will be worthy of respect in the sense that it is the precedent, and I commit to treating it as I would any other precedent of the
There's
Supreme
one, can you explain to me on a constitutional basis the court's decision in Roe, and where is abortion protected in the Constitution?
Abortion is a right that the Supreme Court has recognized is one of the kinds of rights that is unenumerated. It is in that same category of rights that the Supreme Court has recognized.
But the text of the Constitution does not mention abortion.
That is true.
That is true. That is correct. So you agree that the Constitution does not mention the right to an abortion, and yet, through one of the most brazen acts of judicial activism, our Supreme Court created the right through Roe v. Wade. This is why Americans, this is why so many women that I've talked to are really concerned about who sits on the federal bench.
And I want to thank Judge Jackson for this long day and part of it under tough circumstances. You were a model of grace under pressure. At times, things were said about you which turned out to be inaccurate. It was said you called President Bush and Secretary Rumsfeld war criminals. That didn't happen. It was said you also always sentenced criminals too lightly. That's not exactly true. It was said you apologized to a defendant in a child pornography case without any sympathy for the victims, and that wasn't true either. The truth is you've been a judge for nearly 10 years. You've sentenced more than 100 defendants, some to decades in prison. And even child pornography cases my colleagues continue to raise over and over with you. Your sentences were in line with the recommendations of the government or probation office in the vast majority of the cases that you heard. We invited a number of people to come here today, and one special guest was a lady who cleans our office at night. She works the midnight shift, but she wanted to be here today to see you and hear you and stand by your side. And she said afterwards that it was a great moment for her to be in this room today. But she asked me, or she asked my staff, why are some people so mean? Well, I have to tell you, the overwhelming majority on both sides of the aisle were not mean. They were constructive and positive and really raised important questions that we all care about. Some are always going to be a little disappointing. That's the nature of human life. Tomorrow morning, we're going to gather at 9 a.m. for John Ossoff and Tom Tillis. I don't know if America is ready. I know this committee will be ready. And thank you very much. This meeting of the Senate Judiciary Committee will stay in recess.
Judge, I'd like to talk about crime. In 2019, there were about 16,000 murders in America. In 2020, there were more than 20,000. It's a 25% increase in 1 year. 2021 data isn't complete, but we know many cities have reached record levels of murder, including Philadelphia, Atlanta, and Milwaukee. At the same time, the prison population has decreased by about 14%, in part from pandemic policies, but also from fewer prosecutions and weaker sentencings. I think it's safe to say there's a surge in crime, especially violent crime and murder across America. You have noted that some members of your family have law enforcement backgrounds, and I honor them and thank them for their service. Does the United States need more police or fewer police?
Thank you, Senator. As you just noted, I have law enforcement in my background, and I am very familiar with the problems that crime cause in the communities where we live.
Okay, Judge, I'm sorry. We have a few minutes here. you have a lifetime appointment if you're confirmed. I ask a simple either or question. Does the United States need more or fewer police?
Senator, the determination about whether there should be more or fewer police is a policy decision by another branch of government. It is not something that judges have control over, and I will stay in my lane in terms of the kinds of things that are properly in the judicial branch.
Okay, if you don't want to address whether the United States needs more or fewer police, we'll move on to sentencing, which is certainly in your lane. There's been a lot of talk about criminal justice and sentencing approaches and theories today. In general, is someone more likely or less likely to commit a crime if they know that they will be caught, convicted, and sentenced?
Senator, what is in my lane is the consideration of particular cases of
Judge, you've spoken a lot today about criminal sentencing, about the theory of sentencing. You've written about all about your record. It is a very simple question. Is someone more likely or less likely to commit crime if they're more certain that they're going to be caught, convicted, and sentenced?
Senator, I am aware from my work on the Sentencing Commission and not as a judge that there is research into recidivism rates, into rehabilitation, into the factors that go into a determination about whether someone is more or less likely to commit crime. Part of what Congress has taken into account when it determined that one of the purposes of punishment is deterrence is the idea that if someone is convicted and punished, they will be deterred from committing other crimes.
And you've mentioned that, and you've written about that in your writings. There's 4 purposes of punishment. One of those is deterrence. Isn't it inherent in the concept of deterrence that people are less likely to commit crime if they're more likely to get caught, convicted, and sentenced? Why can't you just say that's the case?
Senator, it's not that I'm avoiding saying that's the case.
No, Judge, that's exactly what you're doing. I'm asking a very simple question. In general, is someone more likely or less likely to commit a crime if they know they're going to be caught, convicted, and sentenced?
It's very
part of deterrence.
It's very difficult to answer questions in general when you're asking about things like phenomena related to crime. It's the theory behind deterrence that by punishing someone, they will be less likely to commit the crime in the future. That is a theory that undergirds.
Do you think that theory is correct?
Senator, there is research that supports that deterrence is something that can occur. Does it occur in every case? I can't say that.
Okay, let's turn to something more concrete then. Do you know how long the average inmate convicted for a murder serves in prison in America?
No, I don't.
The answer is 17 years on average. Is 17 years too long or not long enough for a criminal to spend in prison for murder?
Senator, these are policy questions, whether they're in the province of the Sentencing Commission in terms of recommendations, whether they're in Congress. They're not the kinds of things that I can opine about.
So you don't want to opine on whether 17 years is too long or too short a sentence for murder?
Senator Cotton, the Congress has prescribed a number of factors that judges look at when they sentence. It may, in many cases, not be. I can't answer in the abstract in the way that you.
These are very concrete. Let's turn to rape. Do you know how long the average inmate convicted of rape serves in prison in America?
Well, Senator, rape is not a crime in the federal system that I'm familiar with working with, so I don't know.
It's 7.2 months. Do you think 7.2 months is too long or too short for someone convicted of rape to be sentenced to prison?
Senator, that's a policy question about the egregious crime of rape, and Congress has said that the court is supposed to take into account a number of factors when it sentences.
Okay.
I can't answer in the abstract.
Well, these are, Judge, these are not abstract. These are very concrete. And remember, these are just the length of sentence if you're caught, convicted, and sentenced. Let's look at cases in which people are never caught. As I said, in 2020, murders increased by the fastest rate ever in the United States. Do you know what percentage of murders are solved in America?
I do not, Senator.
The answer is about half, 54% in 2020. Do you think we should catch and imprison more murderers or fewer murderers?
Well, Senator, it's very important that people be held accountable for their crimes. So that is a fundamental tenet of the rule of law.
So is that a yes, we should catch more murderers, specifically the 46% of murderers who get away?
Senator, I'm not, to the extent you're asking about enforcement or law enforcement, those.
Judge, it's a very simple and common sense question. 46% of all murders go unsolved. Should we catch more of those murderers or should we catch fewer of them?
Senator, we hold people accountable for their crimes. And so if people are not being held accountable, then that is a problem.
Let's turn to assaults. Do you know how many assaults were solved in this country in 2020?
No, Senator.
44%. So 56% of all assault victims did not receive justice. Do you think we should catch and imprison more criminals who commit assault against innocent people or fewer?
Senator, it's very important that people be held accountable for their crimes. So if they're not, that it would be a problem for the rule of law.
Let's look at sexual assault and rape. Do you know what percentage of sexual assaults and rapes go unsolved in this country?
I do not, Senator.
77%, more than 3/4 of all sexual assaults and rapes go unsolved. Do you think we should catch and imprison more rapists and sex criminals or fewer?
Senator, one of my two uncles was a detective in a sexual crimes and battery unit. So I'm very familiar with that type of crime. It's a horrible type of crime, as are all of these that you are articulating. And it is important for people to be held accountable for criminal behavior. It's fundamental to the rule of law.
Okay. So in 2020 alone, well over 1 million violent crimes went unsolved in America. Do you think we imprison too many violent criminals or not enough?
Senator, it's important for our rule of law to ensure that people are held accountable who are breaking the law in the ways that you mentioned and otherwise.
What do you think the families of all those victims think? Do you think they think that we should arrest and convict and sentence all these criminals who get away with it?
Senator,
That's
I know
right.
what the families of law enforcement officers
say
think,
something on her mouth
because
like,
I'm one of them.
I
I know what crime does to our society. I care deeply about public safety.
She goes back
And as a
to
judge,
yelling.
it's been
She
my
don't want people
duty
to
when
hear.
I was at the trial level.
I am
no longer
recording.
there, but
I
it was
want
the
people
trial
to
level,
hear this
to
dumb,
ensure
crazy bitch
that
with
people
this
are
red
held
jacket
accountable
on
for their crimes.
playing with sexual assault. If
Let's turn to the
if
crime
I-
stop pornography. I know there's been a
did
lot
I
of talk about it today. I
went
don't want to spend much time on it.
did she?
A lot of
Yes,
people
she
have tried to explain the various differences in these
Now,
cases, the
did.
pre-sentence
So, wait,
reports
though.
and
Well,
sentences
I
they got.
originally
So let
started
me
the
just
first
ask you
book
a
that
simple
is the
question about
color
it.
pink. Fuck you.
Should the United
I ain't
States
shit.
strengthen
Well,
or weaken
that
sentences
is-
for child pornographers?
Everybody answer. Who is
Senator,
this?
that's not a
Listen,
simple
we
question. And the
crazy.
reason
I record.
is
I
because
want people to hear.
what this country does in terms of penalties is in Congress's province. You all decide. You all decide what the penalties are. You decide what the factors are that judges use to sentence. If you determine that any set of penalties is insufficient, then it is in your Senator, that's not a simple question, and the reason is because what this country does in terms of penalties is in Congress's province. You all decide. You all decide what the penalties are. You decide what the factors are that judges use to sentence. If you determine that any set of penalties is insufficient, then it is in your purview to make that determination. There are many crimes that Congress has determined warrant mandatory minimum penalties, warrant other kinds of penalties, and that is in your purview to determine.
I say, Judge, I think whether or not we should strengthen or weaken sentences for child pornographers is a pretty simple question, but I'll move on. I think the difference we've heard today gets to this simple fact that a bunch of elite lawyers, whether they're judges or federal prosecutors or public defenders or law professors, think that sentences for child pornography are too harsh. I don't, and I bet a lot of normal Americans don't either. You've said repeatedly that sentencing is a discretionary act, and I understand that, and I agree.
Now, can these people be medically evaluated as far as switcheroo thing? That's it. She said there it is. Then I said that's just sit on them up. Because they know out of Beyonce Noses studio. That's
Crime laws
That-
and
that's
lower
what she's
sentences have been
doing.
advocated, including on occasions, Judge, by yourself. In general, do you think the United States should weaken or strengthen sentences for fentanyl traffickers? Traffickers, not users.
Senator, whether or not Congress chooses to strengthen or weaken penalties for any crime is a determination of this body, which is ordinarily made after study and review, determination. That is in the province of Congress.
Well, Judge, you've said before that sentencing is a discretionary act, so that is literally the job of the judge in many of these cases to determine whether to have a shorter or a longer sentence.
Respectfully, Senator, the judge makes that determination not based on one data point in general, which is what you asked me. In general, should we lower or heighten sentences? A judge is making a determination in a particular case, looking at all of the factors. It's discretionary for sure, but we do so within the bounds of a sentencing range that Congress prescribes. And at times in which Congress decides that a penalty needs to be heightened, they impose a mandatory minimum. Then our range is shorter. And when we're looking at the crime, we're not looking as a policy matter across all fentanyl crimes and determining whether the penalty should be increased. As a judge, we are asked in the context of a single prosecution regarding a particular person who has committed a horrible crime, but also, says Congress, is a person who has a life, who has a job, who has all of the other factors that Congress has told judges they have to look at when they decide what penalty to impose in that particular case between the range that Congress sets. So it's not a situation in which I can, in my role as a judge, tell you as a general matter whether penalties should be increased or decreased.
I have to say, I think that not many Americans, especially not the 100,000 Americans who's lost someone to drug overdose, think these are tough questions. But let's move on. Let's talk about retroactivity. When you were on the Sentencing Commission, you repeatedly advocated for retroactively reducing drug trafficking sentences. So this is a case where a drug kingpin who's dealing fentanyl gets sentenced, and then a few years later, he gets lucky. He gets in front of some new judge who's maybe more sympathetic and thinks he got a raw deal, or maybe he just gets in front of the same judge a few years removed from seeing the faces of the victims of his crime. Do you believe that resentencing years after a conviction tends to reduce sentence lengths?
Senator, respectfully, I just wanted to remark on your previous question and your statement that these are not difficult questions. It's not that they're difficult questions, it's that they're not questions for me. I am not the Congress. I am not making policy around sentencing. My job is to look in a particular case and decide what the penalty should be within the range that Congress prescribes.
I understand. You were making policy, though, at the Sentencing Commission, and you're implementing changes to sentencing guidelines. So my question again is, do you believe that resentencing years after conviction tends to reduce sentence lengths?
I'm not sure I understand your question. Obviously, if you resentence, you're giving the judge another opportunity to look at the circumstances in light of the changed penalties. Sometimes the judge in that new situation will keep the same penalty. A resentencing is just an opportunity for the judge to reevaluate in light of the changed circumstances.
Okay. Almost without exception, retroactively weakening sentencing laws and guidelines lets harden criminals out early. I always hear the argument, I hear it from some of the senators on this panel, I heard a version of it from you earlier, that each case is going to go before a judge and it won't be an automatic release because each judge is going to assess the facts and hear the arguments. In 2014, you said that judges would not likely reduce the sentences in the vast majority of cases if sentencing guidelines for drug trafficking were reduced. I think you missed that one, Judge. Since 2014, when retroactive reduction took effect, approximately 2/3 of all convicted drug traffickers who asked for early release got it. That's 31,614 hardened drug traffickers back in the streets. More than 7,500 of those hardened drug traffickers use weapons in their crimes. So that means that only 1/3 of these drug traffickers who sought to have retroactive reduction of their sentence were denied. Judges, 1/3, a vast majority.
Senator, it's hard for me to answer questions about these numbers because I'm trying to understand whether this is a retroactive release that was a result of the Sentencing Commission's actions or Congress's. Congress made a decision about retroactive reductions in drug penalties. So I'm just not sure what.
But Judge, in both cases, we always hear the argument, whether it's from members of Congress to include senators on this committee or the Sentencing Commission, that we shouldn't worry, there's going to be individualized case-by-case determination.
And that is my experience. That's when there is a retroactive change. So what happens is that whether it's the guidelines that are changed or the laws that are changed, which happens in Congress, and there is a subsequent determination as to whether or not to apply that retroactively, apply that change, so that both the people who get convicted of that penalty moving forward and the people who have already been convicted, both of them get the benefit of the change if the determination is made to make it retroactive. Under that circumstance, we're talking about a penalty change applied to prior people. Each one of those prior people goes back before a judge. And a judge, usually the sentencing judge in the first instance, will reevaluate whether or not to, this is generally, there are some exceptions, but generally speaking, the judge will reevaluate whether or not to give that person the benefit of change. This is an individual assessment. That's what Congress requires in every sentence, and ultimately one that benefits all of us under the law, because judges are being asked to look at these cases and not make just generalized determinations.
So the 2014 comment was typically about the Sentencing Commission, but generally, whether it's in front of the Commission or the Congress, we always hear this argument that judges are going to make these individualized cases and not that many people will be released. I'll point out that of the 1/3 that were not reduced, the vast majority of those were not eligible. The percentage of cases in which a sentence is not reduced for public safety reasons because someone is viewed as too dangerous to release that early is 1%. It's 1%. Judge, do you remember a man named Keith Young?
Yes.
Good. For the benefit of my colleagues, let me quickly cover the basics of his case. You sentenced him in 2018. Keith Young was a career criminal who had previously been convicted of trafficking cocaine. In 2017, he was running a drug business in his house where his children lived and was found with 2 1-kilogram bricks of heroin worth hundreds of thousands of dollars, along with a gun, ammunition, thousands of dollars in cash, and equipment to cut and package heroin for retail sale. The drug lab also confirmed that there was fentanyl in both bricks of heroin. And in one of the two bricks, there was actually more fentanyl than there was heroin. While at the DC jail awaiting trial, Young bragged about his arrest and about how he was a kingpin. Those are his words, not mine. Kingpin. He was even reported calling his wife and brother to give them instructions on collecting drug money from people for him. The prosecutors filed a notice of Young's criminal history, which meant he faced a mandatory minimum of 20 years. You did not seem to like that, Judge. In fact, at his sentencing, you said, this is a quote, that you shared his frustration, that you couldn't give him a lighter sentence. I was shocked to see this in the transcript. I was also shocked that you apologized to this drug kingpin for having to follow the law. You literally said that you didn't think 20 years was fair. This is the quote. And for this, I am sorry. Mostly because I believe in second chances. You apologized to this career criminal, a drug kingpin, in his own words. He was not some low-level first-time drug offender who made a bad choice. That was in 2018. But in 2020, you got a second chance. After Young's sentence, Congress passed something called the First Step Act, which reduced sentences for serious drug traffickers with lengthy criminal records. During the pandemic, lots of criminals like Keith Young tried to twist the First Step Act's compassionate release provision, which was intended for terminally ill elderly inmates to get early release and blame it on COVID. You had none of that, and that's good. You rightly said at his resentencing hearing, quote, COVID-19 is not only present in prisons, and you said that Young's past as a smoker and his claim of various other health issues did not entitle him to early release. If you'd stopped there, I would have cited that as a great example of how you followed the law and made a well-reasoned decision. Unfortunately, you didn't stop there. You said in the resentencing that, quote, Congress did not make their changes under the First Step Act retroactive. That if they had, then you could have given him a reduced sentence.
Up on my YouTubes now.
But then you said, no matter what the law says, and this is a quote, Judge, the court feels as though in this moment, per Mr. Young's compassionate release motion, the court is being called upon to evaluate the length of his sentence
after I wrote
under the revised sentencing law.
That's right.
So it is almost
They said
as
there
if I
it
am
is.
sentencing him to death.
So I can't
And
really click.
If I were to do so, he would face a sentence that would be well below the 240 months that Mr. Young received. And so for that reason, I will grant Mr. Young's motion. Judge Jackson, before you granted this fentanyl kingpin's motion to reduce his sentence, did you contact any of the victims from his case?
Senator, thank you for allowing me to address Mr. Young's situation.
I asked a simple question. Did you contact the victims in his case or not?
Senator, Mr. Young was not released. His sentence was reduced, and I did not contact the victims in his case because there were no victims. He committed a crime, a drug crime. There were no identifiable victims in his case.
Drug crime is not a victimless crime. 100,000 Americans were killed by overdoses.
Understood, Senator, but there was no one to contact
You
because
just
there were no
acknowledged, Judge, you just
identifiable.
acknowledged that you did not release him. You're right, you didn't release him. He filed a motion for compassionate release. You denied that rightly. But you reduced his sentence. He didn't file a motion to reduce his sentence. He
And
wasn't
this is a
eligible
new
for a
era
reduced sentence under the First Step
that
Act
just
because
been
it wasn't
occurring in the
retroactive
month of
towards him.
November.
You took a motion for
They said
compassionate
that
release
is-
to get out of prison
Yeah, I guess it. When we
and put it
that's
into a
serious.
motion to reduce a sentence. So he's going to be released 7.5 years earlier, years from now. Last week, Judge, when we talked in our office, you talked about a lot about judicial restraint.